Good afternoon, everybody, and thank you for joining this webinar on misclassification of workers as independent contractors. My name is Lynn Reinhardt, and I'm a senior fellow at the Economic Policy Institute and one of the authors of EPI's new report on misclassification of workers as independent contractors, the impact on working people, on governments, on law-abiding employers, and others. And we really appreciate your taking the time to join us for this discussion today. We have an expert panel here to talk to us about these issues and the state of play around them, and I will introduce them in a minute. But first, I'd like to just take a minute to describe the format that we're going to follow for this session. And at the top, I want to acknowledge and thank the Friedrich-Ebert Foundation for their partnership and support for this project with EPI, and in particular, Knut Pankman, who is on the webinar, who heads up FES's Washington office. We've enjoyed this partnership and appreciated it very much. So the format that we're going to follow is I'll introduce the panelists briefly. We are also delighted that we are going to have short opening remarks from State Assemblywoman Lorena Gonzalez, who spearheaded the campaign to pass AB 5, codifying the ABC test in California a couple of years ago. So we will hear from Assemblywoman Lorena Gonzalez and then have a discussion with our expert panel about the issues presented around this topic of employer misclassification and the impacts of it. I also want to let people know that there will be another event that EPI is sponsoring that's next Tuesday at 11 a.m., 8 Pacific time for our West Coasters. And that will be a transatlantic conversation on the topic of misclassification, because this is not just an issue here in the United States, but it's an issue that's being tackled globally. So we encourage you to register at epi.org and join us for that event. But first, we're delighted that you're here for this one. And a special thank you to our panelists from the West Coast who had to get ready very early this morning to join us on this panel. So our expert panel. So first we have Lauren Moran, who is the head of the Fair Labor Division of the Massachusetts Attorney General's office. The Massachusetts Attorney General, Maura Healey, has been a real leader in the area of worker rights, fair wages, misclassification, and has appointed top-notch staff to lead the efforts in these areas. And that would be Lauren, who has headed the division for a bit over a year, but has been with the division for much longer than that. Lauren is a graduate of Suffolk Law School, and we're delighted to have Lauren with us today to share her expertise and insights. We also have Bart Sheard on the panel. Bart is a legislative representative at the AFL-CIO, a federation of 56 national and international unions. And Bart, prior to joining the AFL-CIO legislative staff, was attorney at the union-side law firm Sherman Dunn here in Washington, D.C. The most important thing on Bart's resume, however, is that he was a law clerk in the office of the AFL-CIO General Counsel. That was me, and we worked together. So it's nice to see you again, Bart. Oh, and also on Bart, in honor of the weekend that we're approaching, which is Father's Day, Bart is about to be a new father. So good luck on that. We then have our friend Ken Jacobs, who is the director of the Berkeley Labor Center, and he's been the director there since 2002. Ken and his colleagues are great friends and partners of EPI, and we so appreciate that. And Ken and his colleagues have done so much research on workers, wages, employment benefits, and the issue of misclassification. So Ken, we really appreciate you joining us today. And last, and absolutely not least, is Caitlin Vega, a powerhouse in the state of California, who led the campaign to pass AB 5 and led the opposition to Prop 22, which was an initiative pushed by Uber, Lyft, and other platform companies to get exempted from AB 5. Caitlin is now, she's the founder, and she is at Union Made, where she continues the fight for workers' rights in the state of California. And Caitlin, thank you for being here and sharing your expertise and experiences with us today on these issues. So that is our expert panel, and we will turn to them in just a second. But first, we're going to hear a few words from State Assemblywoman Lorena Gonzalez, who championed AB 5.
Hi, my name is Lorena Gonzalez, and I'm the Assemblywoman for the 80th Assembly District here in California. First, I want to start by thanking the Economic Policy Institute for inviting me to speak. Talking about misclassification, the need for the change in labor laws, is one of the things we hold in common, the desire to make things better for all workers. In all honesty, when we did AB5, a lot of people thought it was a gig economy bill. It's often referred to as a target against Uber and Lyft. But in reality, AB5 was much broader than that, and it still is. The reason we wrote AB5 came out of years and years of experiences. I came out of organized labor, so I got to see firsthand misclassification in industries like the construction industry and janitorial industry. We started doing work when I was an assembly member on things like nail salons and the beauty industry. We realized that identifying people as independent contractors had become the favored kind of misclassification that we saw employers really tackling. And then the Dynamex decision came through. And I know probably like a lot of you, we were excited. Finally, the Supreme Court said, this is enough. After years, in fact, decades of Borello, a really confusing multi-part test that weighs things and really adds no certainty to either the worker or the employer, we finally had a clear-cut test. One that would say basically, if you're doing the work of a company under their control and direction, you're an employee. It's common sense. Of course, nothing is that easy. And so we embarked on a multi-year effort to try to ensure that we salvage that ABC test, something that provides clarity for workers and hopefully for employers as well, but yet allowed it to respond to the market forces in California that weren't abusing workers. I think it's pretty clear that in most situations, workers, especially in the service sector, are doing the work of their employer. And the ABC test allows us to have a simple presumption that that worker is in fact an employee. If we really want to create a more sustainable economy, an economy that respects all workers, all communities, especially workers of color and immigrant workers, we have to change labor laws. That started in California with AB5.
Great. Thank you for that, Nina. And we're going to now turn to our panel discussion. I want to encourage people who are watching this webinar to put your questions to the panel in the Q&A part of the screen. We will try to get to some of your questions, but we also have a lot of questions and material that we have already talked to the panelists about wanting to cover. So we'll do our best, but put your questions in the chat and we will try to get to them either now or later. I'm going to turn first to Lauren Moran, who, as I mentioned, is the head of the Fair Labor Division of the Massachusetts Attorney General's office. One of the things that we cover in the new report released by EPI is the fact that many states have adopted the ABC test that Assemblywoman Gonzalez described in the opening video. To better protect workers and their rights. And Massachusetts was actually a leader in that regard and has had the test on the books for, I guess, a couple of decades now. So could you please talk to us about the ABC test, how it's worked in Massachusetts, and how you think from your perspective as a law enforcer it has helped workers in your state?
Okay, thank you so much, Lynn, and the EPI and others for hosting and for publishing this amazing report. And thank you for having me as part of the panel. So we've had our a test on the books for many years in Massachusetts. The most recent amendments were made in 2004. So I had to go back and do the math this morning. So 17 years, and the sky has not fallen yet in Massachusetts. So there's that. But yeah, I, as Lynn mentioned, I've been with the office sort of off and on since 2008. And our office actually issued an advisory back in 2008, which is available online if folks are interested, around this topic. And so it's been a conversation that I've been part of for many years. And So mentioned Massachusetts has the ABC three-prong test. It's sort of called both things. And for purposes of our enforcement, the AG's office, just for a little bit of background, we do the wage and hour enforcement. So Massachusetts, we do have some other tests for unemployment, workers' comp, taxes, but this is the sort of the one that we use that the statute dictates, and it's the same as sort of the ones that folks might be familiar with. So there's the three prongs. Workers have to be free from direction and control. They have to be performing services outside the usual course of the employer's business, and they have to be in an independent trade, occupation, business profession. Massachusetts has no exception. So unlike some of the other state statutes and other things that have sort of been coming along, we have no exemptions in the statute. So it is very clear. And it is a conjunctive test. So I think that that's sort of the key to these tests and the clarity is that the employer in Massachusetts has the burden. There's a presumption that the work that is being performed by an employee, and that presumption exists, and the employer has the burden of proving that the employee is not an employee. And we really believe that clear test, and we have one, thankfully, in Massachusetts, is so critical. It's important so that workers and employers both understand what their rights and responsibilities are. Under the Mass statute, there's almost no ambiguity about proper classification. It's pretty simple. There are some outlying examples of that, but in general, in most circumstances, it is very clear how that individual who's performing services should be classified, and we're very grateful for that. The report does an amazing job. I'll spend just a minute on sort of the why it's important, but the report obviously does a great job of fleshing this out in greater detail. But we sort of always look at this as three sort of big buckets of folks who are harmed by the misclassification. The most, I think, important one, probably, though others may disagree, is sort of the harm to workers. So really that lack of protection. I think that COVID, certainly, again, we've been talking about this for decades in Massachusetts, but COVID crisis certainly highlighted and really shone a light on the disparities and how important it is to have proper classification and have access to things like minimum wage and overtime, but also Massachusetts, our paid sick leave statute and unemployment and workers' compensation, and how just absolutely critical it is for our workforce and for economic security just broadly in our state, to make sure that workers have access to those things. The other sort of big buckets we talk about are just employers. We work with a number of very responsible employers. We receive referrals often in our cases from competitors, from businesses who are playing by the rules, who are doing right, and just can't compete when employers shift the cost and the burden to either the state or the workers. Their competitors just can't keep up, and it's just inherently unfair and wrong. So they're a party that I think sometimes gets forgotten, but is really an important part of the conversation. And then sort of the state, right? We talk about state and federal taxes. Many of you probably know our unemployment and our workers' compensation funds, they're insurance policies that are funded through employer taxes, and they rely on this presumption that they're going to be solvent and they're going to have enough money to fund benefits. And when employers aren't paying properly, that's just not the case. And so it really exposes the state and taxpayers and law, sort of employers who are following the rules, and puts them in a position where they have to make up that difference. And again, it's just wrong from our perspective. So what we've done in Massachusetts is really focused, and any enforcement agency that you talk to will probably tell you the same things. There's limited resources, and so how do we prioritize and decide what we want to work on? So we've tried to focus our energy on both big cases but also small cases. So really recognizing that there's a subset of workers who really are less likely to have access to other legal services or help. We focus a lot of our energy and resources on low wage workers, on immigrant workers, in industries where perhaps workers might have limited English proficiency. And so we've really tried to, and I know there's a lot of talk around gig and big gig and technology in this sphere, but really a lot of our enforcement and work has focused in other industries like construction, as the video mentioned, nail salons, service industries, cleaning, landscaping, snow removal. And it's really, we try to find a balance in enforcement of making sure that we're doing both things. So I think, I don't know how much time I have, but I will say the one other piece that sort of from a lesson learned perspective is in Massachusetts, we really do have a collaborative model for enforcement. So I would say that to other states and places that are sort of looking, it's really critical to have all of the right people at the table. So it's external community partners, but it's also other state agencies. So working with our counterparts and the tax collection agencies, workers' compensation again, unemployment, our Department of Revenue, even our alcohol beverage control, like the license holders, all of that is really important in taking a holistic approach and making sure that we're sort of leveraging all of our resources to ensure compliance. So I think that's 3 minutes, Lynn, but I can keep talking if you want me to, or we can move on.
No, that's
okay.
We will come back to some of that. There's a lot there. Thank you, Lauren, for that fantastic overview of the issues. And I meant to mention at the top and forgot that among the lawsuits that the Attorney General in Massachusetts has brought for wage theft against Massachusetts employers is a lawsuit against Uber and Lyft for denying workers wages in that state. And because that's pending litigation, we may get into that issue in a little bit, but we're going to leave Lauren out of it in terms of talking about pending litigation, because it would be inappropriate to ask her to comment on that. So just saying that at the top. But we'll come back and follow up on some of the points that you made, because there's really a lot there. But I want to turn to Caitlin here, because Lauren has just laid out why, from her perspective, having ABC is so important in the state of Massachusetts. And I was hoping that you could pick up on that. Why was it so important to get ABC in California? And then also, sort of on the flip, less happy side, can you talk a little bit about what the impact has been of the platform companies winning an exemption from AB5 through the Prop 22 campaign? So take it away.
Absolutely. And thank you, Lynn and EPI, for including me in this amazing panel, and for the wonderful work you did on the report. It was brought back a lot of memories and a lot of the arguments that we used in that fight. And I really appreciate you kind of putting it in this broader context. I think Lauren did a beautiful job in laying out the importance of the ABC test. And I would say, as someone who's been working as a labor lobbyist in California for the last 16 years, we dreamed of someday getting the ABC test. We looked at these states that had it and felt jealous and thought they're doing all this great work and this is such a nice, clear protection. I think for us, we grapple so often in California with the fact that we have lots of strong employment and labor protections, but struggle with how to enforce them effectively. And so part of what we always thought was really important with the ABC test is the simplicity of 3 very objective standards that we thought would really allow for much broader and more effective enforcement. I started out with the Teamsters, which of course is a union that has seen many of their core industries destroyed or significantly undermined in terms of wages and working conditions through misclassification. And these are all more traditional industries like trucking, like courier services, really almost any job that involves a driver. Many of those were jobs that kind of flipped the whole industry from an employment model to an independent contractor model. So it's always an issue that I've done a lot of work on, and more broadly as part of the fissured economy, and seeing the use of the rise in contracting out and temp agencies and misclassification as these multiple ways employers seek to not have responsibility for their workforce. And so we kind of always planned at the Labor Fed that we were someday going to try to do a bill on the ABC test. And then there came the rise of the gig companies. And all of a sudden, we had this new, very powerful counterweight that, relied on the same model of misclassification that all these other companies did. But because they did it through an app, they suddenly had this sheen of something new and exciting. And we started struggling with our ability to regulate that. And so in California, obviously, where many of these gig companies are headquartered, we had a few rounds of attempting to come up with some regulations or level the playing field. And the gig companies won, which was kind of a new dynamic, and so we started thinking, well, shoot, how are we going to get this ABC test passed when the gig companies seem so untouchable these days? So there was a lot of discussion and strategy going on within the labor movement. And then one day I woke up and went to work and saw an email and printed it out. And by some incredible miracle, the Supreme Court of California had interpreted existing language in our wage orders that talks about an employer, what it means to suffer and permit a worker to labor. And they said, that's the ABC test. That's what was intended with those words. They tracked it back to the use of child labor and the fact that, companies would use kind of plausible deniability that somehow the parent brought the child and it wasn't their fault. And they said, the point is, you're there doing the work. You're an employee. Dynamex, the case where they issued this really incredible kind of deeply significant, unanimous state Supreme Court decision, was an on-demand delivery company. So it was very much focused on kind of where we see the economy going. And it was also a broad decision. It basically, by interpreting suffer and permit to mean use the ABC test to determine employment status, the implications were very, very broad in terms of who this would apply to. And so, we rejoiced at this decision. We were very excited. I read it over and over thinking like I had missed something and it couldn't possibly be true, but it was. And as excited as we were, we realized the Chamber of Commerce and the employers and the gig companies and kind of everyone on the business side was equally, the intensity level was equal, but on the other side. And so they did some unprecedented actions in response to the Dynamex ruling. They petitioned the state of California to suspend the ruling. They asked the governor, then Governor Jerry Brown, not to enforce the ruling. They really said this is going to end business in California forever. Very, very dramatic hyperbole. So we did AB5 as a way, I think Assemblymember Gonzalez said it perfectly in her video. It was to preserve the ABC test and the Dynamex ruling for as many workers as we could, and for the workers where we felt like it was most important. And so just to say a word on how that ties into Uber, because as she said, people often said, oh, that's the Uber bill. And we were like, no, we've been fighting misclassification for like 25 years. It's the everybody bill. We're trying to figure out, do we need it to apply to doctors or can they go back to common law? Do we need it to apply to real estate agents or can they go back to, we're tinkering around the edges, but really this is about everybody. And so the point I want to make here about the gig companies is that it's really them and not us that are arguing that they should have a different standard. We're not targeting them. We're saying one law for everybody. You're all bosses controlling workers, making money off the work they do. Let's have one law that applies across the board. And they're the ones who have advocated for a different standard simply because they use an app to dispatch workers. And I think that became very quickly kind of the question of AB5 was, do companies that use apps deserve a different standard? Are they so fundamentally different than traditional employers that they shouldn't have to follow the same laws that all other employers now will have to under AB5? So one point I want to make on that is we won on AB5. The legislature agreed with the labor movement and with workers' rights advocates that every worker was deserving of the same rights, regardless of how they get dispatched to a job. And it was very important to us to highlight that there are apps that dispatch construction workers. There are apps that dispatch hotel housekeepers. There are apps that dispatch nurses to go give people shots. Like every job can be done through an app it really has no bearing on whether that worker is independent or their own business or sets their own working conditions. We won that on the first round. Then we saw what $220 million could buy, the most expensive initiative ever in American history, with the companies, dramatically outspending the labor movement and able to purchase themselves an exemption. So I feel like we are both hopefully a happy story of the democratic process working and the legislature standing with workers on this very deep principle, and also, the limitations, particularly where you have an initiative process that allows money to win over all else. And so that's where we are now, is that workers who do food delivery or passenger delivery, rideshare drivers, have their own unique test that basically says if you work through an app and choose when you work, you're a contractor and therefore exempted from virtually every kind of right and protection that other workers get.
We're going to come back to that too. Thank you, Caitlin, for that great overview of the California story. Ken, I'm going to turn to you here. Both Lauren and Caitlin have talked about the breadth of the misclassification problem and the cost of the misclassification problem to workers, to law-abiding employers, to state and local and federal governments. You've done a ton of research in this area, so I was hoping you could put some numbers on the table for us and quantify a little bit what it is that we're talking about here and the impact. But first, please unmute so we can hear you. Okay.
Yeah. Sure. And first, I want to add my congratulations to Lynn and your colleagues at EPI for a really great report, and encourage everybody to read it. I think it's important just to start in terms of saying, what is it that we're talking about when we talk about the rights and benefits of misclassification? Because employment is a set of rights and benefits under the law, and those include the right to the minimum wage and overtime and paid rest breaks, and so our social insurance programs, where there's all this talk of portable benefits. And what we're talking about here is the right to social insurance, unemployment insurance, workers' compensation insurance if someone's injured on the job, state disability, as well as health and safety protocols. In some states, paid sick leave and family leave. And of course, under federal law, the right to organize. And I think it's important we think about the concept here. And as Lauren and Caitlin said, this isn't just about platform workers. Misclassification is widely prevalent in low-wage industries where women and people of color are overrepresented. Hairdressers, maids and housekeepers, as well as construction, janitorial, and of course, trucking. We found in California, 1 out of 4 janitors and construction workers and nearly a quarter of truck drivers are classified as independent contractors. Now, we don't know the exact number of those that are misclassified or correctly classified, but based on what the evidence from where there's been audits, there is a significant number who are misclassified. And I think it's important to note that AB5 did a really good job on addressing these issues. And Lauren noted, of course, in Massachusetts, it's across the board, and that's best, great to have one test, as Caitlin and Assemblywoman Gonzalez went through the whole process in California of preserving the ABC test and expanding it to the rest of labor law. Their negotiations really worked. They ended up with the 2/3 of workers who are independent contractors in their main jobs, were those lower wage occupations that Lauren mentioned that they're focusing their enforcement on, are all covered by AB5 and the ABC test. About 10% who are independent contractors in their main jobs, but are in professions like doctors, lawyers, and accountants, were carved out. And then there's about a quarter who have some additional tests to include. So, commending, they really dug in and made sure they were getting to those right occupations. And then just another note, when we're talking about scope, Lauren mentioned the cost to the public. Well, in California, the first ruling against Uber and Lyft on unemployment insurance on an individual case by California Department of Labor Standards Enforcement, saying a worker was counted as an employee for the purpose of unemployment insurance was in 2015. And of course, that was an individual case and they did not change their practice. We estimate that over a 5-year period, going from 2014 to 2019, had Uber and Lyft paid into our unemployment insurance system, that would have been a little over $400 million. If you go just from that first DLSE ruling to the pandemic, we're probably talking closer to $500 million not paid into our unemployment systems. And then, of course, when the pandemic happened, the companies then went and worked to get public employment unemployment assistance, pandemic unemployment assistance, so that they could get unemployment funded by the taxpayers without having paid a penny into the system. So these effects on workers are significant for all the reasons that we've talked about, and the effects on the public are significant when we really look at what kind of taxes are being lost.
Thank you, Ken. That's super helpful to get that context. And that is kind of a jaw-dropping number, $400 million over 5 years in one state. So you add that up nationally and yeah.
And that's just two companies.
Exactly.
Large ones in this context. But if we think of misclassification more broadly, the numbers really are very high.
So you referenced the right to organize as one of the rights that's tied in the United States to employee status. And that is something that the labor movement and its allies on Capitol Hill are trying to get changed through the adoption of the Protecting the Right to Organize Act. And so I want to ask Bart Sheard, who is a legislative representative for the AFL-CIO working on the proact, if you can talk a little bit about the fight to try to get ABC into the right to organize and what the dynamic has been, some of the challenges you faced, and whether you're facing the same sort of pushback by the platform companies that our other panelists have described in the wage and hour area. So Bart, over to you.
Absolutely. Thank you, Lynn, and thank you for having me. The proact fight is just, incredibly passionate and powerful, and there's a real palpable energy behind the proact. And, it's not just within the Beltway or on Capitol Hill. Workers all across the country are out advocating for the proact. Since the bill passed in March in the House with bipartisan support, the energy for the proact has just grown. I mean, we've seen thousands of worker events across the country because, people on the ground really understand that the proact is the way to empower workers and to shift the power dynamic to make sure that workers' interests are actually at the table. And so, it's incredibly important that we have a president and President Biden who has actively called on Congress to pass the proact and to send it to his desk. And so I think that that's also helped with this energy. And in the Senate, we have 47 co-sponsors of the bill. And so there's extremely strong support for the bill there, and we're very happy to see that. And last thing I'll say about the current fight is that it's also inspiring that it is not just labor who's behind this. Like you said, civil rights groups understand the importance of the proact, environmental groups, human rights groups. They all understand that the proact is truly the way to shift our country away from this kind of race to the bottom that we've seen in terms of workers' rights. So that's fantastic to see. Like my colleagues on this panel have talked about, there is severe opposition to the proact as well, no question. Employer groups, Uber, Lyft, the Chamber of Commerce are really creating this oftentimes just false and disingenuous messaging around the proact, and a kind of sky is falling fear mongering that is going on, and it's understandably worrying workers who are consuming this campaign. There's a lot of talk about the proact and the ABC test will make businesses just go out of business. They won't be able to operate anymore if their workforce is considered employees. because of the ABC test. And of course, we know that's not true. You know, multiple states have the ABC test, and there happen to still be businesses, and there happen to still be workers, and it seems to have not destroyed freelancing or creative professional work or anything like that. And you know, there's been a particularly loud fight against the ABC test from people who want to continue to be independent contractors, who don't want to be employees. And the fact of the matter is that the ABC test is a test, and it is applied, and a worker is either deemed to be an employee for the purposes of bargaining or not. I mean, the proact only applies to the NLRA, right? Which I think is extremely important to remember here. It doesn't change wage and hour laws. It doesn't change overtime laws. The proact is specific to the right to bargain. It doesn't, if someone is deemed an employee under the proact, it doesn't change anything about your work status at that moment, except for the fact that you're protected by the National Labor Relations Act. You have the ability to join together with your coworkers to advocate for the changes that you want to see without fear of retaliation. You have the ability to organize and to join a union if you so choose. So to the independent contractors out there who are who are saying, no one wants to be an employee. We all love the status that we have. Well, if that's true, that's fantastic. You don't have to join a union. You need majority status to join a union. And so if the fact is that, first of all, you were deemed to be an employee under the test, and then an organizing effort took place, you don't have to join a union. It's a choice. And another kind of talking point that we've been seeing is that with the ABC test, it's the end to worker flexibility. No one will be able to have particular hours or particular working conditions. As an initial matter, if you want to be able to have flexible work schedules and to have a say, a union is the way to do that. To have collective bargaining rights and the right to actually talk about the wages and hours rather than employers just unilaterally, making these changes, a union is the way to do that. But putting that aside, there are sectors that are union that have this type of flexibility. The idea of being an employee for the purpose of the National Labor Relations Act and having flexibility that I think many, freelancers or other people, they're not mutually exclusive. You can do both. There are musicians, building trades workers, camera operators, all of whom perform their work for multiple employers and are protected by a collective bargaining agreement at each employer. This is not the death of freelancing. And, I think the message is becoming more and more clear. I think as we're able to talk about the ABC test and talk about the National Labor Relations Act, groups that have been kind of stirred up into being scared of the PROACT are starting to understand. So for instance, groups like the Freelancers Union who were initially against the PROACT, but then, when it passed the House, understood that, the PROACT doesn't change federal state laws, and now they're supportive of the PROACT. So it's a difficult campaign, but we're winning it, and we're doing well because workers know and people understand that the PROACT is necessary and that the ABC test is not the death of business. It's just a way to make sure that employers cannot evade their responsibilities for their employees. And the right people will be deemed to be employees, and true independent contractors, people who actually perform their own work and won't be employees under the ABC test. And I think that message is becoming clear. And we have a fight on our hands because there's huge lobbying efforts against the PROACT by the business community. So the fight continues, but it's going very well.
That's great. Thank you, Bart, for that overview of the federal fight. I'm going to turn back to Lauren for a follow-up question on something that you were talking about. But first, Ken, there was a question in the chat for a clarification on one of the numbers that you mentioned in your remarks, if you want to address that.
Yeah, our estimate on what Uber and Lyft would have owed to California for unemployment insurance is a little over $100 million a year. So the 500 million was saying between the first case that they had saying that an individual was eligible for unemployment in 2015 up to the pandemic would be about $500 million.
Great, thank you for that. And your comment about how in California, there was this individual case in the unemployment system finding that a driver had been misclassified leads me to the question I want to ask you, Lauren, which is, I think some people think, okay, great, we got ABC. We've got this really great legal test. And so you can wave the wand and voila, everybody's covered and protected, and they're getting paid the wages that they're due, and they're getting unemployment when they're unemployed and workers' comp when they're injured on the job, that it's kind of automatic in its implementation. But we know that actually that's not the case. And I was hoping that you could, sorry about the plane in the background, talk a little bit about the challenges, some of the challenges that you face in your office, actually making this thing stick and bring rights to working people.
Sure. So, I guess there's like sort of, and this is an oversimplification, absolutely, but there's sort of two buckets of employers, right? There's the ones who are responsible, trying to do the right thing, and then there's the ones who are just going to break the law no matter what the law says. And so, our enforcement, I mean, one of the wonderful things about the way the statutes are written in Massachusetts is we have a ton of discretion when it comes to enforcement. So we really approach our cases in different ways depending on sort of which bucket we encounter. But yeah, there's no magic wand. There are plenty of employers still in both categories still, at least from our perspective, misclassifying workers in Massachusetts. And I think that will continue probably, forever, just like every statute that we have. There's people who are breaking them, and unfortunately, that's just the reality. But I would say for just practically for the employers that we encounter who we really do believe are trying to do the right thing and maybe made a mistake or should have known something they didn't, we really approach those cases trying to get people into compliance. So it really is a goal of ours in some of our more recent cases that we've done, especially in gig sort of more gig sort of technology platform cases. Our goal is to get those companies into compliance to make sure that when we do that, we also, sometimes we'll do press releases or other sorts of announcements so that folks know, when we're coming into Massachusetts and you're relying on this business model, you have to do things a different way here. And so in addition to trying to get back, which is often our goal in other cases, restitution to workers or making sure their earned sick leave banks are brought up to where they should be, really compliance is the main goal. For companies that are not looking to come into compliance or are doing this because it does save them a ton of money and it allows them to be competitive in ways that they wouldn't be able to be if they were properly classifying their workers, we try to use stronger enforcement tools. So we use everything in our belts, which is tool belt. We've got a civil and criminal enforcement authority, and we will use both depending on sort of how egregious the facts are in a case. I would say, I guess the sort of biggest challenge is sort of there's two biggest from my perspective for companies that really fall in that second bucket. One is cash, and really just the proliferation of shift from what we saw 10 years ago. And we dream of these cases now where you walk on a project and everyone has a 1099 and it's very clear and everyone's being misclassified and we can identify people and we know how many people. Now often we work on, especially in certain industries, we work on we start to investigate a company or companies and we realize there's no records, there's no sort of documentation of anything. Payroll related or employment related, and that it proves very challenging from an enforcement perspective, which is why it's a smart shift for employers who want to break the law. We have a hard time. We still have to prove our cases, right, in law enforcement, and so not having records is a huge impediment, and then often not having workers, right? So again, we talked about some of the industries where we prioritize, and there's lots of reasons why workers would be reluctant or would not want to participate in an investigation. Everything from immigration status to potentially other issues. There may be exposure from the fact that they haven't been paying taxes properly, or potentially collecting unemployment benefits while they're working, or there's child support, or there's all these other reasons why they just may not want to get in trouble or fear the retaliation or fear not being able to be hired again. So, that I would say that's the biggest. And then I think someone mentioned in one of the comments too, just sort of and it's related to, but not exactly the same as, but the sort of the fissuring, right? Like the many, many layers now of companies and employers when we're doing an investigation, trying to figure out who is the actual sort of employer or owner of an individual who's performing services. And that's why we sort of push, and when we talk about things, it's sort of having a strong independent contractor test, but also having a strong joint employer or lead employer law. Also, they sort of go hand in hand and are really important, so that for either disappearing employers or judgment-proof employers, that there is another sort of avenue for enforcement and for holding people accountable and getting really workers what they are entitled to under the law.
I want to ask the other panelists if they want to jump in here and add anything on either the issue of protecting workers from retaliation when they bring claims forward, or the whole fissured workplace, how this fits in with the fissured workplace joint employer issue. Bart or Caitlin or Ken or all of the above, do you want to add anything to that?
Sure. I mean, regarding the PROact, I'll just say, we very much recognize that the fissured workplace and joint employment is a huge issue, and the PROact seeks to address that. One provision of the PROact is to amend the National Labor Relations Act to adopt a joint employer standard that actually makes sure that the entity who controls or has the ability to control employees' working conditions is actually at the bargaining table. What we've seen, and I'm sure my colleagues have seen in California and across the country, are workers who seek to organize, who seek to bargain and to advocate for themselves with their employer, and are only told, "Oh, I'm sorry, we don't control this. We have a contract here, and another entity controls this part of your job." Well, then where does that leave workers to go? That leaves workers with no one to bargain with. So the PROact seeks to adopt the Browning-Ferris standard from the Obama board in 2015, and to make sure that, look, if an entity controls this part of your job, they have to be at the bargaining table. It's a very simple concept, and it's a simple fix for a huge problem.
I wanted to make a point just tied to kind of what Lauren was talking about in terms of the work that they've done in enforcement. And I'm really excited and interested to learn more about the joint enforcement efforts that they have there, because in some of the analysis that we've done kind of about what happened here, we had the big win with AB5, and then very shortly after that, we had the ballot proposition. And one of the big challenges is that we weren't able to show change between the point of passing AB5 and there being an initiative on the ballot that looked like it was to help rideshare drivers and delivery drivers do better. And it's like, here we had just passed a law that gave them every single right and protection that every worker in California has, which is like hundreds. And the companies were able to say like 3 little fake unenforceable things were a win. And that to me was a lot, because was in large part due to our inability to have fast, effective enforcement, which of course is super hard. Enforcement's not fast. And we didn't have enough time. And in fact, our AG and many city attorneys are still engaged in this effort. I believe that they launched a lawsuit to enforce AB5 like in May of the year that Prop 22 went on the ballot. But it just wasn't enough time for us to be able to say, look how much better things are. And so instead we were having to argue off a base of this group of workers having nothing, even though the law entitled them to so much more. So I think that just points to how critical it is that we find tools to be able to show that these laws work, that they actually do result in changes in the economy. We saw a little bit of this as we were working on AB5, where I think at one point, like UPS put out a press release and said, we're going to create a same-day delivery operation based on employment status, because AB5 is going to require employment status. And now we can compete and do same-day delivery using employees. Of course, once the delivery companies got themselves exempted, that didn't actually happen. And so it's, there's this kind of tension in terms of how much you can force change when the companies think maybe they can buy their way out of it. But certainly being able to show that we can enforce these laws and make people's lives better puts us in a much stronger position with the companies, and helps us expose how kind of flimsy their guarantees are.
Thank you. That's a really insightful comment. And as you're talking, I'm also thinking, and why don't you throw a pandemic on top of that too, just to add to the challenges of showing strong enforcement of a law that hadn't been on the books all that long. Ken, do you want to add anything here, or should I move on to my next question?
You can move on to the next question. I think we've had some great responses.
Yes, definitely. Well, my next question kind of relates to what you've been talking about already, which is this effort. The day EPI sent out the announcement of this seminar, in the New York Times, there was an article. I don't know if people can see the headline, probably not, but it said, Uber and Lyft ramp up efforts to shield their business model. And there have been a lot of articles about how, following up on their successful and, as Caitlin said, very expensive campaign to get themselves exempted from AB5 in California, they are taking the show on the road and trying to bring this model to other states. And so I was just wondering if our panelists, and Lauren, we're going to leave you out of this one because of the situation that your office is right in the middle of, but whether the other panelists want to say anything about the effort by these companies to either get themselves exempted altogether or set up another way of approaching labor rights and labor relations in their industry. Anybody want to comment on that?
Yes.
Yes, Caitlin, I thought you might. What can we learn from your experience in California?
So a couple things. One is that when they ran their campaign of Prop 22, I think Bart touched on this whole issue of flexibility, and they made it about preserving flexibility for this one very specific small group of drivers who love doing work with no rights or benefits and just want everything to be flexible. They did also make some changes moving toward Prop 22, where, for example, they allowed drivers to know their destination ahead of time, and gave little bits of additional control as part of that campaign, all of which they have since revoked, which again goes to, I think, Bart's point about how flexibility comes with a union that bargains you those protections, because flexibility that the company can give you can just as easily be taken away. And we really saw that happen. But in terms of their messaging, the whole Prop 22 campaign was rideshare drivers love their flexibility, let them keep it. The day they won, maybe the next day, they basically said, we are now going to create a third kind of employment and forge these coalitions for independent work, which are about every industry and every job. And I think that is the most fundamental lesson, is that there's no such thing as the gig economy. That's my own opinion, but I would offer that as a lesson for how to navigate these discussions, because they will make it very specific when it suits them. And they'll say it's about one kind of worker, and it may be a kind of worker that a union doesn't represent, or that feels far from your core industries that you're seeking to protect. But something I learned in AB5, because of course I got contacted by every company in America that wanted an exemption from AB5, I got contacted by app companies that do teaching and wanted teachers to be exempt. There is literally no job that they can't make an app to supply workers to do. And so for me, it's always been very clear that we can't bifurcate and say there's one kind of worker that can have less rights than everyone else. I think in California, we have been fortunate in being able to eliminate some of those longstanding exclusions like farm worker overtime. We enacted farm worker overtime. We brought farm workers closer to the same standard. We brought domestic workers closer to the same standard on overtime. We're fighting now to get domestic workers covered by Cal OSHA, because overall, we all understand every worker deserves the same kinds of protections and rights. And I think that we let them win when we let it be about one kind of worker and what those workers actually do or don't want. as the wonderful Professor Vina Dubal, who everyone should read on this topic because she's amazing, but she says, nobody wants a boss. That's like a general, of course, no one wants a boss. We understand that. That doesn't mean that workers want to not be paid while they're circling around looking for rides. That doesn't mean that we want to move toward a piece rate system for all kinds of work where you're only paid when there's a customer, right? Restaurant workers get paid an entire shift. They don't only get paid when somebody's there at the counter ordering their food. And I think what we're really facing here is a fight over what kind of economy we're going to have and whether companies can find ways to increasingly distance themselves from their workforce and place the entire risk onto the worker. If no customers show up today, that's on you and you don't get paid. That would be unthinkable in any other industry. But what I think these companies made very clear in public after they felt like they had defeated the labor movement on Prop 22 was that's the real vision. It's not about rideshare. It's not about food delivery. It's about everything. And that's why I think this fight's so important.
Anybody dare go after that? Caitlin, that was very powerful and very informative, and that you can create an app for anything and any kind of job is a very scary vision that you've just put in all of our heads. Go ahead, Ken.
Yeah, I just want to add just how nefarious Prop 22 is. I mean, not just the sort of the general assault on democracy where a group of companies can buy a law that regulates themselves and a law which basically has no enforcement mechanism. And prohibits the state from making any changes. It requires a 7/8 vote, preempts all local laws on this topic. But also they came up with something that they claimed they were creating a set of rights that workers would have, that it would be a basic minimum wage, that there would be access to a healthcare benefit. And then of course they designed it in such a way so that that basic minimum wage, while it's theoretically higher than the state minimum wage, it only applies to a certain portion of workers' time. It doesn't include the time waiting between rides. They have a mileage reimbursement that's half the real cost of driving and doesn't apply to a third of the miles. And then a healthcare benefit that almost nobody qualifies for. And we're already seeing that already. The number of people who get the funds from it is minuscule. And so they set this up in a way where they were claiming to create some alternative set of rights, where we estimated that the total value of it is about $5.64 an hour in terms of an equivalent wage. And so as they go on the road trying to push these kinds of concepts elsewhere, I think it's really important that people understand what they did in California and what that law does. And as Caitlin mentioned, the kinds of things the companies have done since the law passed, actually reducing drivers' rights and independence, so that people have a real picture that this is what the fight is about when it comes to their state. And just to note on the recent issues in New York on this, where there was discussion about creating a new collective bargaining process around the transportation network companies, but then at the same time taking away all sorts of rights, and it had written into the draft that the law, that standards couldn't be based on actual driving time or on actual expenses. I think it's helped in New York significantly that New York City already had much higher standards in place. So it was very clear, as Caitlin mentioned, it was very clear what would be taken away in that context. But I think that it's very important for people to understand what's happening in California as people look to fight that elsewhere.
Thank you for that. And those are really helpful pieces of information, because we do know that there are proposals in play in a number of states: Massachusetts, New York, Illinois, some others that I'm forgetting. So really helpful for advocates in those states to hear from you about what the true experience has been in California under Prop 22. We are running up against time here, which I cannot believe, because time flies when you're fascinated by the comments of your panelists, that's for sure. But I want to ask each of you one last question, which is this. And I'm going to ask you to, give it your best minute in answer to this question. You've all made a very compelling case that having ABC matters and makes a difference for working people. So what should people who care about this issue do? What should they take away from this webinar, and what should they do next? And you can figure out what order you want to go in. So final comments. What should people who care do? Oh, really? Now you're going to get shy? Okay. Okay, Bart, I'm going to call on you. Okay.
Perfect. Thank you. Everyone who cares about this issue should really look into what's going on in their states on this topic, but also look into the PROAct. The PROAct has a lot of support in the Senate, but to get it over the finish line, we need more. And it's going to take everyone, the labor movement, and outside the labor movement as well. And especially if you live in Virginia, Arizona, or any other state where your senators don't co-sponsor the PROAct, make sure to reach out to your senators to get them to co-sponsor the PROAct. And then lastly, I would say, talk to your coworkers about these issues. Talk to your coworkers about what you want to see in your own workplaces, and how your state and the federal government can help you do that. This isn't the labor movement, and these issues are truly driven by workers. And so everyone should feel a part of this and become a part of it.
Great, thanks. Anybody else? There's a softball answer to this question that you could all give, which is, if advocates care about this, they should read the EPI report.
Right, that's what I meant to say. Read the EPI report.
Right. So I'll just leave it with that little piece of self-promotion for the Economic Policy Institute, and just thank you so much to the panelists for an incredibly informative and interesting discussion on these important issues. We hope that our audience found this informative and helpful, and will continue to follow up on some of the resources that you talked about on this webinar. And until next time, just really a million thanks from all of us for sharing your time with us today. Thank you, everybody. Take care.